Good morning, everyone. It's a time to have this sharing session again. And today, we are really happy to have our Singaporean employment aid. Okay. Before we start it, I would like to give an introduction about AsiaHRM and also myself. My name is Rita Chui. I'm the founder of AsiaHRM. And for AsiaHRM, actually is a HR community whereby we can share and connect with each other with all the HR related issues. And we hope that through this community, we can help each other to add value. And today, for me, I have been in the HR field for many years. And the reason that I created this community is that when I was working in the regional human resources field, I just find that having the right kind of information, having the right connection, this was a challenge. That's why I've decided that I should go for this HR community, and having the sharing session is one of the highlights of this community. And today we are very glad to have Caroline, who is going to share with us the Singaporean Employment Act. So Caroline actually has 4 sessions in her presentation, and she will invite questions after she's done with each session. Okay, so without further ado, Caroline, you're in control. Thank you.
Thank you, Rita. Thank you for sharing with us the aspiration in terms of and the objective of setting up the team. I think it's a very good objective to have. I think like you, I do have that same challenge as well. But let me start into this presentation now. So today I'll be sharing in terms of Singapore labor law, but because labor law is so wide, I will just share more in terms of what are the proposed changes, so that our friends who have companies in Singapore can actually know what are the acts that's going to come into place, as well as what are the updates that's available on since 1st of April this year. Okay, so today we are going to have 4 sections. So the sections are actually proposed amendments to the Workmen Injury Compensation Act. The other one is the new Employment Act, which has been effective since 1st of April. And because Singapore just has its National Day, so there are actually some announcements which the Prime Minister has made with regard to that will actually impact into HR and the workforce in Singapore, as well as today's session is very timely because we will have a new revised regulation that will come into place on 1st of September, which I think HR will probably need to take note, because in Singapore, regulations can have rather strict enforcements. So the first one is actually talking about there is actually a proposed revision in terms of the Workmen Injury Compensation Act. So, and in Singapore, employees, if they say they're injured at work, they can actually sought for compensation in terms of 2 avenues. One is the common law, the other one is called the WICA, or the Workmen Injury Compensation Act. So I have actually drawn out a table in terms of the difference, and why some people, they would prefer the common law, especially for those that are more seriously injured or permanently disabled. They will usually go for common law because that will enable them to have larger claims. So the WICA has actually a limit to the claim that they have, and for people who go for WICA, usually they are the compensation is not as much, or rather it's more like a not so serious injury that doesn't result in permanent disability. And also for people who rather go for a faster kind of settlement basis. Because WICA is actually processed by the Ministry of Manpower, so claims are a lot faster in that sense. So these are actually 3 forms of compensation. So as for WICA, we have one compensation, which is the medical expenses, and then the medical leave wages, as well as the permanent sum of compensation for, or rather lump sum compensation for permanent incapability. So if you can see, do take note about this. One thing about this is that you need to look at the formula. There is this annual, or or rather average monthly earning. So this is actually something that we will all need to take note of, because that it will come very useful in terms of calculating in terms of medical leave wages. Okay, so these are actually all the proposed acts. So it's not really in place yet, but you can actually see this coming on very soon. The estimated time of implementation will be towards fourth Q this year, or first Q next year. So if your company has actually any presence in Singapore, you might want to just preempt the company with regard to this. So with regard to what is actually the change about? So they're actually trying to balance the responsibility of employers and then the rights of the injured. So this is actually a comparison of what the changes will be like, or rather why they would prefer, why they are looking at the change as well. So one thing is, they want employers to be more responsible. They want they want to have a new regime with regards to WICA, because now different insurers can have different policy wordings to the WICA kind of insurance. So what they are actually looking at is to standardize it, because there are a lot of times company has bought WICA insurance, but however, they are not able to claim because of certain policy wordings in the insurance. So now government is going to step in and say that, hey, no such things. We are going to give you a standard policy, a standard coverage, so which means that you will actually need to follow, and so that workers can be covered more comprehensively, and employers don't need to worry and say that, hey, I don't know whether this company covers this, and rather the other insurance company will cover something else. So the government is going to put a stop to that, and they will have actually a standard kind of policy. So in the rights of the insured is here. So it's actually going to look, what is interesting to know is that instead of in the past, they will not actually allow, or rather you need to report the injury only if it's more than 4 days of medical leave, or rather medical certificate, or MC in this instance, but then if that employee is on light duty, then there's no need to report. However, going forward, this is something that all of us need to take note, will be they will need to report any instance of MC or light duties, regardless if it's due to work injury. Okay, so this is actually this is actually the proposed amendment, the proposal, and what employers need to do. So this is actually quite a comprehensive kind of, this is quite a comprehensive table already. So as you can see, new regulatory regime for WIC insurer. So only licensed insurers are allowed to sell MOM approved WIC policies. So this is something that the company will need to take note, to make sure that the insurers that are selling that you're buying the WIC insurance from are actually approved insurers. And then so actually the same thing, MOM will still retain the adjudication and enforcement role, and then it will conduct independent third-party audits. So if, let's say, even if the insurer decision is saying that no, we are not going to they're not going to admit the claims, then MOM can actually still come in and say, no, you need to pay. Yeah, so that's what the new proposed amendment is about. So why do they want to amend? This is because safer companies can enjoy lower premiums as compared to less safe companies. What it means is that because the claims, or rather the policy information and claims information will be shared among all insurers. Currently, it's not really shared. So it's only when upon inquiry of another insurer, then the insurer will release certain information. So from going forward, there will not be such a case whereby claims data will actually be centralized into one database, and all insurers can actually look at what the claims background and information is in order to actually provide the premium amount. And also there will be a streamlined process to auto claim unless the employees opt out. What it means is that the moment the claim, or rather they have actually reported and put up the workman injury with MOM, then the MOM will actually just process it straight through without having too much of hassle, whether, you know, the employees need to file this and that and whatsoever. So MOM will just process it at straight go. Okay, that's the end of the first part of proposal. Are there any questions?
Caroline?
Yes.
Yeah, I have a question about this VICA, okay? I
Mm,
think VICA is similar to what we have in Hong Kong as the employee compensation, which is a
mm,
mandatory cover
yeah,
to be extended by the employer to the employees. So
mm.
when it comes to the compensation side, what will be the compensation be? Like, would it cover any injury cost or the hospitalization charges and so forth?
Okay. Just now, I think WICA is actually covering various portions. So one of the portions is actually the medical bills. So it will cover like consultation charges, hospitalization charges, etc. So that's one part WICA will cover. So the other part that WICA covers is actually the salary. So say for example, if let's say, you know, some people they have fixed OT. So instead of they have their basic pay and they have their fixed OT as well, or other overtime. So what WICA will do is that they will actually have, just now I showed the average monthly earnings. So what happens is that they will actually pay for lost wages during that leave, the medical leave period as well. So WICA does actually cover both of them.
When it comes to like hospitalization or so forth,
Mm.
how much would the government, how much would this VICA cover? Would it cover 100% or how long does it cover and so forth?
Yep, it actually covers 100% until recovery, or up to 1 year from the date of injury.
Okay, got it. I don't have other questions. Thank you.
Welcome. Okay. If we have no other questions, maybe we can do, we will look at the Amendment of Employment Act with effect from 1st of April 2019. So they're just very simple amendments, but let's go back to the background of why there is actually the need for change. The last time when Singapore had any review or change in terms of Employment Act, that was in 2012. However, because in Singapore there is a very interesting environment whereby any change of acts will actually need consultation, or rather three parties will come together to represent different sections of Singapore, I would say, to actually make sure that the change is applicable. So what it does is that usually it's proposed by the Ministry of Manpower. They will be, and any acts will actually be in consultation with the two bodies, which is, one is the NTUC, which is the National Trade Union Congress. The other one is SNEF, or SNEF in short, which is representing the employers. So what it does is that it's actually a tripartite relationship, which is quite interesting in Singapore. So any acts that actually impacts in terms of manpower, or rather the workforce, it has to go through consultation with the Ministry of Manpower. You have your NTUC and SNEF, because NTUC represents the workers. So they actually will look at how it impacts the workers, and SNEF actually will look at represents the employers in Singapore. So a lot of companies are actually members of this SNEF. And what it does is that three parties will sit down and see how it will impact the workers as well as the companies, which are the employers. So that is why usually in Singapore our manpower change is actually widely supported by the employers as well as the workers. Okay, so what we need to take note is this this provision. So this provision will actually impact a lot of people. So in terms of this provision, however, will not apply to managers and executives. So if you look at this provision, it actually talks about your normal hours of work, your payment of overtime work, as well as the rest day. So, okay, in the past, we actually have core provisions that only cover employees, asset managers, and executives earning more than 4,005. Okay, but then from 1st of April onwards, core provisions will actually cover all employees, regardless of whether they are managers and executives. So what are actually core provisions? Core provisions will actually include like salary payment within 7 days after the end of salary period, and then annual leave of minimum 7 to 14 days, depending on the length of service. So there is actually a minimum annual leave. So with each year of service, then it actually adds on. But then most companies in Singapore, they actually directly offer either 12 or 14 days of annual leave. So most companies are fine with this. So we have paid sick leave, which is 14 days per year. Up to 60 days is if hospitalization is required. So what it means is that if, let's say, this employee has taken 7 days of medical sick leave already, and unfortunately this employee gets hospitalized, and this employee actually gets hospitalized for, say, 60 days, but because he has actually utilized 7 days of sick leave earlier, so what it means is that the employee will only be entitled to 53 days of hospitalization. It will actually be entitled to 53 days of hospitalization, and the remaining 7 days will be either unpaid leave or some other arrangements that the company might have. And in Singapore, we have 11 gazetted holidays, with the exception of an election year, whereby the workforce will actually get 1 more day off. Yeah. So it has been rumored that Singapore election will take place sometime this year. So let's see how. And employment records, of course, we need to maintain proper employment records and to issue written key employment terms and itemized payslip. This is issuing written key employment terms and itemized payslip is mandatory. So any company that is here will need to remember that they will need to issue key employment terms to the employee when the employee joins. And every month there should be an itemized pay slips to employees, regardless of whether they are full-time, permanent, part-time, or part-time employees. And for dismissal, there will be a recourse for wrongful dismissal. This will be actually held by a body later, which I will actually introduce later. Okay, this is actually a summary of changes, because previously, I think the salary threshold for non-workmen to qualify will actually be raised from 2005 to 2006. So previously, non-workmen, if let's say they are actually protected up to, or rather they are actually payable up to 2005. I mean, I would say that they are protected up to a limit of 2005, but now because they realize that economy has changed. I mean, a lot of people are earning a lot more, so they have actually increased it to 2006. Although it's not a huge increase, but there are more than 10,000 people who are actually impacted in this case. So for wrongful dismissal, in the past, it's actually heard by the Ministry of Manpower. However, because they wanted a more centralized and a more effective way of handling dismissal claims, they've actually set up an organization known as the Employment Claims Tribunals, which is called the ETC. So they have actually trained officers who actually will actually hear the case. So before, in Singapore, if you want to sue an employer, you cannot directly just go to court and sue them. So you will need to go through this ETC. They will actually go through mediation, and then if let's say the mediation doesn't work, only then they will give you a letter to recommend and say that, hey, you can actually go and file a court case in this. So this will actually help to reduce the load in terms of the courts as well. So the other one The other thing that will change is actually that has changed is actually the medical certificates from all registered doctors and dentists will be recognized. In the past, only government doctors and dentists and all company approved doctors and dentists are recognized for granting this paid leave. However, come 1st of April this year, MCs registered by all doctors or other MCs issued by all doctors that's registered under the Medical Registration Act, they will actually be recognized. However, the interesting thing is that we have TCM, which is the traditional Chinese medicine. For those doctors, currently they are still not recognized. So we are looking forward to see how it will be developed later on, because a lot of people are starting to realize the benefits of TCM. So there are actually requests going to the government to say that, hey, I think we should change the act, and we'll probably need more we need more recognition in terms of TCM practitioners. However, due to various concerns, that is actually still being considered. Okay, that's the end of the part for 2.0 for the latest updates in terms of things that's going to, or rather that has been enacted on 1st of April. Are there any questions on that part?
Caroline, can you tell us more about this wrongful dismissal? What is
Hmm.
considered as wrongful and what is the consequences?
Okay, for wrongful dismissal, say for example, companies, okay, in my experience, companies have sometimes when they want to save costs, they will try and find reasons or other unreasonable reasons to dismiss an employee. So that's actually considered as wrongful. Say, for example, or when the employee is, after maternity or rather on maternity leave. Singapore maternity leave is 16 weeks. So if let's say for example, the company decides to terminate a staff during maternity, yeah, so and it's not because the company is like closing down or is in liquidation, etc. If the company terminates an employee that is during her maternity period, that's actually considered wrongful dismissal. So other things such as like, oh, I'm not giving during if let's say there is a misconduct, there is no inquiry that's being done, there's no proper disciplinary action that has been met out, then that is actually considered as a wrongful dismissal as well.
How about if we have an employee who does not perform up to our company uh, expectations,
Mm,
and somehow our company does not keep any proper record about his performance-related issues.
mm.
So one day we just fire him because we just think that he's not doing well. We don't expect improvement from him. In this case, will it be considered as wrongful dismissal?
Okay, as long as you give him in sufficient notice, say for example, he has signed a contract to say that, his dismissal, or rather, if let's say he needs to resign, or if the company wants to terminate him, he will need to give 1 month. 1 month notice, then we will need to give him that notice. Either that, or we pay him 1 month and tell him to go. So that's one way of doing it. The other way of doing it is, as most companies in Singapore will do, they will actually do up something called a PIP, Performance Improvement Plan, and then they will document and say that if let's say that the employee doesn't hit that milestone, then the employee will be given letter of warning, and then subsequently he can be asked to go.
Okay, so if that's the case, can I say that any companies in Singapore can hire anyone as long as they pay them in accordance with the Employment Act? In other words, if we just serve them the notice, the notice
Mhm.
period is specified in the contract, then we can terminate anyone without any reasons. Can I say that?
Yes, because actually in the Employment Act, it doesn't mention that there is a need to give a reason. However, under MOM guidance, they say that it's best to give employees a reason to terminate them. However, it's not compulsory. So companies can
Oh.
actually tell you that, no, we don't need your service anymore. So we are going to pay you 1 month, or let's say you will be serving, this will be serving you notice. So in 1 month's time, the employee can be exited from the organization.
Oh, okay. And that would not be considered as wrongful dismissal, right? Okay, understand. So actually the employees in Singapore are not that well protected.
Yes, but usually if let's say employees feel that they are aggrieved, so they say that I demand to know for a reason, I want to know a reason. So what they do is that usually they'll go to ETC, and then they will tell ETC that, oh, they have been, so usually employees will tell you that, I've been doing well, I've been contributing to the company. Why did the company just terminate me like that? So if let's say ETC finds that, oh, okay, since if you are really so aggrieved, you really want to know a reason, then they will have to write to the company and say that, hey, please provide a reason. Yeah, so they can actually go to the avenue.
Understand. Okay, got it. So I don't
Yeah.
have other questions. Thanks.
Thank you. Okay, this is the interesting thing. Singapore just had its National Day on the 9th of August, so which is earlier this month. But as with every year, there is actually an announcement that's given, or rather a National Day rally that will be held by the Prime Minister. It will actually announce the future plans of what Singapore is going for. So these are actually the latest announcement whereby it will actually impact the workers as well as HR. So retirement age of Singapore workers will be raised from 62 to 63. Yes, in Singapore, we work very, very long. So because Singapore is a very small country, so our population is roughly about 4 million now. So we really need people to contribute to the workforce. So the retirement age has been raised from 62 to 63, and it will be done in 2022. This is actually to give employers the time to redesign jobs and to actually to look at their processes in terms of and work and see how they can actually retain these workers to help them, and actually eventually it will be changed to 65 by 2030. So this is actually a gradual process. This is actually what Singapore does usually. Whenever we implement a policy or we implement a legislation, it's usually very slowly eased into the workforce so that employers and employees have time to react. And as for re-employment age, in Singapore, re-employment is compulsory unless the person is not performing or due to ill health is not able to perform the job the company requires. If not, then after the retirement age, the company will need to re-employ these workers. So the re-employment age will be raised from 67 to 68 in 2022 and eventually to 70 in 2030. But after 2030, there has been talks previously when I was in the union, there has been talks that it will be gradually increased to 72 years old. So for Singaporeans, I think we will enjoy a very long work life if we really want to. I think by the time after 2030, we will probably see another amendment to say that, hey, re-employment age will be increased to 72. So the next one is actually in terms of CPF. CPF in Singapore is called the Central Provident Fund. That is actually similar to the Hong Kong idea of MPF. But for this, actually, contribution comes from two sides. So one is actually the employee side and the other one is the employer side. So so employee and employer will actually have a different percentage of contribution. This is actually the government's initiative to help citizens build their retirement nest so that they actually have something to look forward to when they retire. So now workers aged 55 to 60 will enjoy full CPF contribution of 37%. This 37% is actually broken down into two parts. So 20% will come from the employee, which means the workers themselves. So what it does is that in Singapore, if let's say you apply for a job and you say that, oh, my job, my salary, I would like my salary to be 5,000, and the company agrees. Then what happens is that from this 5,000 every month, the company will deduct 20% and it will contribute into the CPF. So which means that, and then the company will pay an additional 17% on top of the $5,000 to actually contribute into the CPF. So, however, there is a ceiling. It doesn't mean that, oh, if you earn 10,000, you will contribute 37%, you get 37% of the 10,000. It doesn't work that way because there's a cap ceiling of $6,000 for now. So what it means is that you only need to pay 20% of the $6,000 you earn, and the employer will only need to pay 17% of the $6,000 you earn into the CPF. So the remaining amount, so the $4,000 will not be required to contribute any CPF, and it will be going back to your own pockets. Yeah. So gradually, if you can see, in the past, for employees who are age 55, the CPF contribution rate is actually lower. So however, now as we realize that more and more people tend to work longer, so they have actually extended the full CPF contribution rate up to 60 years old. And for 60 years old, CPF rates will begin to taper down for employees who are after 60 years old and level off after 70. So what it means is that the CPF contribution rate will start to drop when the employee is after 60, when the employee is 60 years old or more. So these are the percentages that they will have. So this is actually something that companies need to put into their budget, and also when they plan for their manpower cost, this will actually be something that they will need to look at. Okay, are there any questions on that part?
There is Caroline, there is a
Hi.
question from Celine.
Sure.
Okay, actually she wrote it on the chat box. It says
Oh,
that,
sorry.
okay,
I
yeah,
didn't see.
chat box, yeah, it means termination can happen at any time as long as the employer found that the employee's performance is not to par, right? Okay, I think you already answered that question about employee termination, right?
Mm.
Okay.
Yeah. However, there's one thing that is a bit tricky, whereby if the employee is on maternity leave, so the 16 weeks, so that is a very tricky period. So usually I would advise, if let's say company really needs to terminate an employee, do not do it within the 16 weeks. So you can do it after that 16 weeks, which is fine, because no matter what, we will still need to accord 16 weeks of maternity leave to citizens in Singapore for maternity. So, and the interesting thing is, because government co-pays half of the maternity leave, so yeah, so if let's say if there is a termination, I think we can wait off that 16 weeks.
How about paid sick leave? When somebody is on paid sick leave,
Mm.
does the employer have the right to terminate them?
The employer can terminate, but then there is no law that says that you can't really terminate an employee during paid sick leave. But the thing is that you need to have very, very strong grounds. If not, then it's going to be a case which will impact the company negatively, because employee can go to ETC and say that, hey, you have, I'm sick, and then the company is being very inhumane and has terminated me. So then ETC can actually look into the case and say that, hey, I think this person doesn't warrant a termination, but since you have terminated, so it's either you take the person back, or ETC will actually say that you need to pay a certain amount of compensation. So usually we try not to, and also because Singapore, although union is not very it's not very dominant in the public, but it's actually very effective in the back. So usually, if let's say if you terminate an employee because of ill health and things like that, then we might get into trouble with the union as well. Then union can actually say that because in the union there is actually certain provisions to say that you need to give employees a certain number of months of full pay, and certain number of months and half pay. Yeah, and a certain number of months of no pay in order to terminate the employee if it's due to sickness. But performance-wise, if the employee is sick, then there's nothing to talk about performance, because the employee is just not working.
I see. But how does the trade union work in Singapore? Because you mentioned that the trade union is not that strong in Singapore. But how does it work? Does it mean that every company is required to be a trade union member and so forth?
Right. Thank you for the question. Because in Singapore, I wouldn't say it's not that it's not strong. It's just that it's not very obvious in the front, but they work from the back. So usually, trade union in Singapore, they are very nice. They are not out to punish an employer because of certain wrongdoings. They want to resolve the issue. So sometimes when they resolve issues at the back, nobody in the front or in the public knows about it. So what it does is that not all companies are unionized. I would say in Singapore, about 60-70% of companies are unionized, especially the financial institutions. A lot of them are unionized. And the other ones are like the teachers' profession is unionized. The Port of Singapore workers are also unionized. So there are certain companies, the smaller companies that might not have been unionized, especially the newer ones, because and also the small medium enterprises whereby they have not many employees, then those are companies that might not be unionized. Yeah, so what happens if with the union is that if let's say the employee has a matter, so it will actually bring up with the union, and then the union will actually decide to see if there's a case to it, or if there's something that if it's something that the union needs to do. So if let's say the union decides to take up the case, then of course the union will actually speak to the HR. They will go to the HR, and then they will conduct a session or rather a negotiation session or a sharing session or a fact-finding session to actually find out like what is going on, and then to see if the employee really does have a case. If they do, then of course they will actually go into negotiation and then to try to find a win-win solution. If not, then of course they will bring up to the tribunal court as well, and to actually file a case against the employer.
Let's see. How about if my company is not unionized? Can the trade union step in?
If it's not unionized, okay. The thing is that we have two types of membership in Singapore for union members. So they have the general branch member and the ordinary branch member. So if let's say the company is not unionized, the employee can also be a member of the NTUC, which is National Trade Union Congress. So sorry. So if let's say they are actually a member of that, trade union can still try and write to you, but then there might not be so much of negotiation. Some employees choose to disregard it. So then it's actually up to the employee to see whether if they want to bring the case up to ETC for mediation. Sorry.
I see. So Caroline, what you are saying is that if an employee, if has issues with my employer, I would either go to the sort of labor tribunal, as you mentioned earlier, or the trade union. Am I
Yes.
correct?
Yeah.
Okay, but which one is more powerful, or which one will help me most as employee? Of course, I will go to the one who is more effective, right, in handling my case.
Sorry. It's actually usually most people, if they are not part of a unionized company, most of them will go to the ETC because they find it more straightforward. So directly, they will they'll actually go for mediation. So, however, there are certain parts that they feel that after mediation and all, it will take a very long time, and so they will actually go to the union, and then union will actually tell them what are the steps, what next steps of action that they can take. If they go to court, then they can actually attend the court session together and provide advice to the employee.
Okay, so even though the company that they are working at is not unionized, they can still be given this option. Oh, that's good.
Yes.
That is good. Here's a question for Celine again. How about the staff who joined the company already for certain years? Can they be terminated for reasons of non-performance?
Yes.
Yeah,
In
I think you
Singapore,
mentioned that. Yeah.
yeah.
Go
In
ahead. Yeah.
Singapore, we are a performance or we are a performance-driven country. So what it means is that in the past, it's even worse, whereby there is everybody believes in elitism. So the elites will definitely get the best, and they will get a lot of other things as well. So for performance-wise, I think it has always been a performance culture in most of the companies in Singapore. Um, they will usually have some form of performance appraisal or performance management process. So for employees who are non-performing, because performance appraisal, actually we do it like at least once a year. So if let's say we realize that the employee is not performing, then the same thing, we can either give them a performance improvement plan, or if we think that we're not going to just waste time with these employees, which I won't recommend. But if let's say they have decided to go down that route, then of course they can actually just give um, the notice period, or rather or notice pay, and get the actually terminate the employee that way.
Kelly, you just mentioned about elitism, right? I
Mm,
understand in Singapore, the government really love developing those who are considered as high flyers and so forth. So when it comes to the company perspective, would
mm.
there be anything offered by the government in promoting this kind of sort of the supreme work performance or elitism and so forth?
Actually, Singapore is trying to move away from elitism, because we realize that, you know, with the population, elitism is a bit too stressful. So yeah, so they are trying to, in terms of academic wise, they have actually decided to do away with too much of elitism. So they are actually gradually edging in the less, or rather, I would say the not so elite people, I would say. So if you look at Singapore's education, they have actually started in, especially for secondary school, we have something called the express stream and the normal stream. And normal, in the past, we only have normal, which is, you know, the usual. But now, because they realize that, you know, people have different aspirations, they have different aptitude towards studies. So they have the normal technical, normal academic. So depends on what the child is like. So similarly, Singapore workforce wise, instead of promoting, you know, elitism in terms of studies academic, there are a lot of other things, such as like training programs, which is why Singapore government has always encouraged people to go for training and retraining. So in terms of this, they are trying to, you know, not promote elitism so much, and they recognize that different people have different aspirations. Some are late bloomers or whatsoever. So they rather people concentrate in terms of their interest as well as what's needed in their job, to go for training and retraining. So many years ago, Singapore government has given $500 into each Singaporean account for them to attend courses. And when they attend courses, it can be subsidized. So say for example, last year, or no, 2 years ago, I attended this class called ACTA, which is the Advanced Certificate in Training and Assessment. So that course itself, if you were to just go there like that, I will need to pay about $5,000, thereabouts, 4,000 plus 5,000. So due to certain considerations such as like age and experience in job, etc., so I get a 90% subsidy from government. So what it means is that the school will still charge me 10%, and they will claim 90% of the cost of the course, or rather the module, to the government, and the government will pay them 90%. And because it's only, say for example, if my cost, I remember I only had to pay 480 thereabouts. So what it does is that it can actually deduct from the $500 that the government has given into the account for me to, for Singaporeans to actually go to do learning. So which means that the cost is actually technically free of charge for me. So these are things that the government is doing to help the workforce upgrade themselves.
Great. I don't have other questions.
Okay. If there are no other questions, the very final last part. This is actually on personal data protection. Sorry, it's not action. My typo errors. Personal Data Protection Act. So this is actually not new, but then there is actually a new requirement. So in the past, a lot of companies use our NRIC, which is the National Registration Identification Card, which is the ID. In Hong Kong, we also have the ID. So they have been actually collecting these numbers as reference numbers. So now, coming from 1st of September, which is tomorrow, it will be illegal to be making copies of the identity card if you do not have a legitimate reason, such as like applying for bank account or to verify who you really are, such as like applying for bank accounts or applying for a telco service or some other government related needs that you need. So if however, for HR wise, the impact will be like you can only collect NRIC for really specific employment purposes. And for the IC numbers, right, there's another section whereby you need to maintain, or rather how you use them. That is something that you need to take note of. Say, for example, a lot of buildings, when you enter, they will take down your NRIC number and your phone number. So in Singapore, from tomorrow onwards, they are not allowed to do it. They're not allowed to take your full NRIC number. They can actually take the last 3 or last 4 digits of NRIC number just as an identifier. They cannot take the full number. And if they do, then of course, anybody can actually go to the Personal Data Protection Committee to actually complain about this practice. And then of course, the government, then they will actually act on it and fine the company for it. Yeah, so this is just a small reminder that this piece will actually come into play on 1st of September. So if there are any processes within the company, say for example, one of my companies, they like to use NRIC number as their employees benefit system login. So from tomorrow onwards, it will not be allowed. So yeah, so companies who have presence in Singapore will need to take note of this. Yeah, any questions on this?
So you mentioned that how about we use the copy for purposes like phone bills or other purposes is still not allowed, or is still allowable?
Okay, phone bills is allowed. So because they need to ascertain that you are actually the real person who is actually using the service. So they will actually allow for phone bills. Like applying for bank account will also be allowed. Like or registering your child into childcare or primary school, all these are allowed. But then other than that, then it's really very restrictive in terms of that. You know, in the past, when in Singapore, a lot of times when we take part in like maybe if we go to supermarkets, we take part in lucky draw, they will ask us to fill in your NRIC numbers. So in the past, you are able to do that, but now we can't do that anymore. Because that is actually a part of collecting NRIC numbers. So what they will do is that they will say that, oh, please write down the last 4 digits of your NRIC number and your phone number as identification. Yeah, so that is the change in Singapore.
Yeah, interesting. We have a question. Okay, so does it allow for job application?
Yes, for job application, it's definitely allowed, but then they cannot withhold your NRIC. So what it means is that they can actually make a copy only when you join, not during interviewing. So when you interview, you do not need to, they are not allowed to collect your NRIC number or photocopy your identification card, unless when they have actually recruited you and said that, hey, welcome aboard, we are making you this offer, then they can actually get the full information from you in terms of collecting NRIC and making a copy of the NRIC, because they need to know, because of anti-money laundering considerations as well, they need to know who they are paying and who they are employing. And also making CPF payments will actually still be tied to NRIC numbers. So only when confirmation of employment, then it's allowed.
Great, yeah. Mm-hmm.
Yeah. So are there any other questions?
Any questions from the participants? I think that's all. Yeah, that's all for the questions. Mm-hmm.
Right, great.
Hi, may I ask a question, please?
Sure.
Actually, I tapped you privately, and may I know what is MOM abbreviation for, please?
MOM abbreviation is actually Ministry of Manpower.
Ministry of Manpower. Thank you.
Yes.
Yeah, got it.
Welcome.
Thank you so much.
Welcome. Yeah. So,
Other
yeah.
questions, Adeline?
Thank you, Rita. I have no other question. This is
Thank
only
you.
one question. Thank you
Thank
Okay.
so
you,
much.
Adeline. Thank you.
Thanks to
So,
you, dear.
thank you. So, okay, so that's all from you, right, Caroline?
Yes.
Thank you. Thanks very much for the great sessions. I learned a lot about the Employment Act in terms of its, especially on the recent changes. So thanks, Caroline, again. And we are recording it, and we are going to put the video clip on the company website of AsiaHRM. And at the same
Okay.
time, we'll organize a watch party whereby we'll invite our members to watch it, and the dates is to be advised. Okay, so thanks again, and hope everybody have a nice weekend. Bye now.
Sure.
Thanks.
Thank
Nice
Bye
you.
weekend.
bye. Thanks. Bye. Bye
Bye.
bye.
Bye, dear.
Bye.